Risk of war and the shipping industry. The risk of war may increase insurance rates, cause charter parties to be cancelled, and change the port of discharge or places of delivery designated in charter parties, bills of lading, and service contract. It will probably increase freight rates. A carrier may have questions regarding whether its vessel may avoid certain port or whether it may increase its freight rates to cover the additional war risk insurance premium. Insurance coverage and the risk of war. A ship owner will generally insure his vessel for hull war risk at the value of the ship, and this hull policy traditionally include a protection and indemnity (P&I) endorsement for an independent value, which again is the ship value. Where this cover is in place, the P&I Club in the international group have traditionally offered an excess P&I war risk cover of $100 million, which cover acts as an excess to the traditional hull and P&I cover, not as a primary cover. As an example, let us assume that a vessel had the traditional hull war risk policy with a P&I endorsement, and that both elements carried independent limit equivalent to the ship's value, say $25 million. If the vessel paid $60 million for cargo loss due to war, the hull war risk P&I endorsement would pay its limit of $25 million, and the P&I war risk cover would then pay the balance of $35 million. War risk cover is provided worldwide at one base rate, but underwriters will exclude the more dangerous areas. This excluded zone can then be insured for an additional premium, usually at an enhanced rate for the period ship entered the zone and as declared by the ship owners. The excluded zones are subject to change as decided by the underwriters and instantly applicable as soon as declared by the underwriters. They have recently been expanded as a result of the attack on the World Trade Center in New York City and the Pentagon in Washington, D.C. Carriers traveling within this excluded zone must declare each voyage in the excluded zone and purchase extra war risk coverage for that voyage. The effects of war risks are not, however, limited to increase of an insurance premium. War risks may cause charter parties to be cancelled, voyage to be frustrated, and cargo to be discharged and declared delivered at alternate port. Carriers may wish to avoid certain port and to increase their freight rates to port excluded from the usual war risk coverage. The general doctrine of frustration may allow a carrier to avoid certain port, while the term of carrier's contract and tariff may allow a carrier to increase freight rates. Frustration. The leading United States decision on the issue of frustration is Transatlantic Financing Corp versus United States. In Transatlantic, the vessel had been chartered to carry grain from the United States to Iran. The usual and customary route of the voyage was through the Suez Canal. Given the outbreak of hostilities there, the vessel was required to transit around the Cape of Good Hope, and the owner subsequently asserted a claim for the increased cost. In considering the issue of the impossibility of performance, the court set forth the guiding principle. When the issue is raised, the court is asked to construct a condition of performance based on the changed circumstance, a process which involves at least three reasonably definable steps. First, a contingency, something unexpected, must have occurred. Second, the risk of the unexpected occurrence must not have been allocated either by agreement or by custom. Finally, occurrence of the contingency must have rendered performance commercially impracticable. In that case, and in many other cases, the owner was denied the extra cost incurred by traveling around the Cape of Good Hope. The owner could have provided for the contingency in the charter party or other contract of carriage. The court didn't consider the extra expense to have made the voyage commercially impracticable. Tests similar to the frustration test are used to determine whether a vessel should refuse to load cargo for a port at which the carrier should realize a dangerous situation would develop, or whether a vessel should deviate from her intended voyage if the carrier should realize during the voyage that a dangerous situation would develop. If the carrier should have realized before the voyage that the dangerous condition would develop during the voyage, the contingency would not be unexpected. In that case, the carrier should refuse to accept cargo for that port or make special arrangement, including war risk coverage, to call at the port. If a dangerous situation were to develop during the voyage and thus an unexpected contingency were to occur, the carrier could treat the voyage as first-stated. The different kind of contract of carriage handle this risk in different ways. It could discharge the cargo at an alternate port and declare the contract completed and the freight earned. The case of United States of America versus Waterman Steamship Corporation, 1981, provide good example of unexpected and expected contingencies. There, the United States Department of State Agency for International Development Aid contracted with Waterman for the carriage of goods to Saigon near the end of the Vietnam War. The vessel loaded cargo during April 1975. On April 29, after loading cargo and while en route from New York to Houston to load more cargo, Saigon fell to the Viet Cong. When the vessel reached Houston on April 13, Aid directed Waterman to discharge all 8 cargo loaded for Saigon. Waterman claimed that the freight for the cargo loaded had been earned. Aid argued that Waterman should have realized that Saigon would fall and should not have loaded the cargo. The court examined that Waterman should have realized at the various times it loaded cargo and determined when Waterman should have realized that Saigon would fall. Waterman was entitled to keep the freight for the cargo loaded before Waterman should have realized that Saigon would fall, but had to return the freight for the cargo loaded after Waterman should have realized that Saigon would fall. Charter parties. While charter party issues primarily involve the close interpretation of the relevant clauses, it must be remembered that, regardless of the presence or absence of any clauses related to war and similar activities, a voyage may be abandoned if there is a state of war and a vessel would have been required to enter enemy territory. However, in practical terms, what must be considered are the terms of the particular charter party, as in the clauses in the standard form of the charter parties that deal with the risk of war, as well as increased insurance premium. However, given the typical clauses in charter parties in which the risk of war has been allocated and addressed, including those circumstances justifying the termination of the contract, this extra-contract doctrine of frustration is largely academic.